Is now resumed.
Clauses 23 to 25.
I'm sorry, Madam Chair. May I, for the record, treat with the observations just before we left? Madam Chair, I've had a chance to look at the report of the JSC on anti-terrorism in specific regard to the language at page 12. The recommendation, which was debated and therefore stands, is that the committee, page 12 of the JSC report, your committee recommends that the Parliament agree with its proposals for amendment to the bill attached as at Appendix 8. Your committee further recommends that the Parliament consider and adopt the Anti-Terrorism Bill 2018 as amended. In those circumstances, and for the record, the bill which was put for second reading is the bill which was amended by the Joint Select Committee and which was presented to this House in the context of the circulated and adopted report of the JSC. That motion was carried. So for the record, the only amendments that are germane for consideration are those which we have considered already and which we're proceeding to consider. I just wanted, for the benefit of the record, to put to bed that issue as to whether we ought to revert to any business. It's pellucidly clear, having reflected upon the report, that we're treating with the bill which came from the JSC that was amended. It was that bill which was put for second reading and which we're now discussing. Thank you, ma'am.
Thank you, Attorney General. And for the benefits of members, I think this is all that is before this committee for consideration. Okay? So we proceed.
Clauses 23 to 25.
The question is that clauses 23 to 25 stand part of the bill. The question is that clauses 23 to 25 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 23 to 25 now stand part of the bill.
Clause 26.
The question is that clause 26 stand part of the bill. Attorney General.
Madam Chair, both the government and the opposition have circulated amendments, proposed amendments to clause 26 of the bill. Clause 26 of the bill, Madam Chair, treats with the Section 22AA of the Parent Act. And Section 22AA is the section which treats with the FIU and the powers which the FIU have and the manner in which they ought to be governed. The government proposes that this particular clause be amended such that we adjust the language appearing at 22AA subsection 2D by circumscribing the type of information which the FIU will give to the Attorney General and harmonize it with the approach agreed by the Joint Select Committee, that information only be the relevant information. I should remind that the purpose of this information, the power which the FIU is exercising under 22AA, is to facilitate listings by the Attorney General under Section 22B of the Parent Act and Section 37. 22B is where you do the listing of entities, designated entities, and individuals, and 37 is where you treat with the forfeiture provisions. So we are proposing the language as circulated here so that we can be sure that the FIU treats only with the information that it ought to give. I remind that this is built upon the formula of the existing law, in particular Section 25(3), Section 32, Section 33, and Section 37 of the existing Act, as it has stood law from the period 2005 to 2010 where there was an amendment, straight through to today's date. This has been the existing law. It is in those circumstances, therefore, that we propose the amendment to Clause 26 as circulated.
Okay. Member for Point Chappell.
Thank you, Madam Chair. We have some amendments into Clause 26. and where we are asking in clause 26, section 22AA, we would like to delete the proposed subsection D and substitute it with a new subsection, and I quote, our new subsection would be furnishing the Director of Public Prosecutions with information required to facilitate an application under section 22B, where a designated entity has funds in the Trinidad and Tobago. And
Okay. All right, so both amendments deal with that sub-paragraph D. Yes?
Yeah.
Attorney General?
Madam Chair, thank you. I wish to put onto the record the reply to the proposals coming from the member for Siparia as articulated by the member for Pointe-a-Pierre. In the amendment proposed by the opposition, the request is that the FIU furnish the Director of Public Prosecutions with information required to facilitate an application under 22B. Let's start with what 22B is. 22B, which comes under Part 3A of the Parent Act, Financing of Terrorism. That law was introduced in 2010. In 2010, we saw the beefing up of this particular provision of the FIU. The law stood in 2005. It was improved in 2010. The listing for terrorism has been the law. From 2005 to 2018, the law has been that the Attorney General is the creature in law to do listings. 2005 to 2018, the Attorney General has been the creature. The Constitution of the Republic of Trinidad and Tobago, at section 76(2), prescribes the Attorney General to be the entity that conducts civil litigation. This is civil litigation. To now suggest that the DPP should be the person who is to receive information to facilitate an application under 22 is to completely and totally and inexplicably reverse the law 2006, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. 14 years of law on the back of this amendment. The DPP does not have the constitutional authority to conduct civil litigation. That is not the DPP's function under Section 90 of the Constitution. The DPP has no involvement in civil listings, and I cannot, in those circumstances, support the recommendation of my learned colleagues.
Member for Orpuch East.
Thank you very much. To the Attorney General, again, I just want to raise this matter that the issue here, as you well imagine, is beyond this amendment. It's a much deeper issue here. And to recall that this issue was raised in the Joint Select Committee as well. Yes. It was raised there by all three members representing the opposition. And I recall raising this issue and speaking to a development that we saw taking place across the board where there was a certain blurring of the line between civil and criminal. And I said it on the record in those meetings that we were very concerned with the, I use the term encroachment, but not to mean, certainly not to mean you, but the encroachment of the Attorney General outside of a defined perimeter of civil proceedings, in that, yes, proceedings may be civil, they may be involving the High Court civil matters, but in the build-up to that and in processes and sub-processes and so on, dealing with these civil proceedings, there are issues of information coming to the attention of the Attorney General information which could lead to criminal prosecutions, information which could be used, information which could be abused. In our political system, as you know, as you recognize, the Attorney General is in a different role than that in other jurisdictions, and even in other Commonwealth jurisdictions as well, and certainly is not the same political structure and so on as the United States of America. And the concern, I think, that the opposition leader is sharing here, not only with this amendment, it's throughout, is that there is a request for the Attorney General to reconsider this approach and to have another office holder undertake the work insofar as it relates to the gathering of information, having sight of information that can or may be used not only for civil order, but for criminal prosecution as well. And I think that is a deep concern that the opposition share now. It was a matter raised in the Joint Select Committee, I repeat, that the authority to receive information that can lead to criminal prosecution and so on ought to be the Commissioner of Police or the Director of Public Prosecution. And the Attorney General in our system ought not to be privy, ought not to have sight, ought not to be involved in handling in any way information that can be used or can be abused when one serves also as a politician in a contentious political environment particularly. And that is why I believe at the amendment to 26, we speak about replacing the Attorney General with the Director of Public Prosecutions with information required to facilitate an application under 22B pursuant to that, where a designated entity has funds in Trinidad and Tobago. And that is the thinking behind it. I think you gave some type of explanation, I believe, in the winding up, but it's something that we require, something we strong about. It was raised before, and now it is in this format that the Attorney General in our system ought not to be crossing that line, particularly as it relates to receiving information from the entities we are dealing with here, the FIU or other entities as well, that can be abused, that can be misused, that can be the source of some political machinations. And I think I'll leave it at that for now.
Member for Chaguanas West.
Thank you, Madam Chair. The Attorney General in his response indicated that this is the way the law has been for several years. But I want to point out to him, Madam Chair, that when you look at the existing 22 AAD, the FIU was confined to merely furnishing the Attorney General with information required to facilitate an application under Section 22B, where a designated entity has funds in Trinidad and Tobago. So now you move to an amendment, you remove that, and you're saying now you're furnishing the Attorney General with information required to facilitate an application under Section 22B and Section 37 spontaneously or upon request. So the Attorney General in this situation allows the Attorney General merely to make a request from the FIU and get the information, or the FIU spontaneously. I don't know whether if that is proper legal approach, spontaneity in this environment for the provision of information. But I think that it raises another issue in a matter as dealing with counter-terrorism, whether it is not appropriate to insulate the office of the Attorney General and really have the established office of the DPP. And this is what the amendment by the Honorable Leader of the Opposition speaks to, that you have an independent, insulated body, that's the DPP, dealing with matters of this nature. So that in the current situation that the Attorney General is asking us to support, there are no preconditions in which the AG has to satisfy the FIU prior to requesting information. As soon as the AG requests information, the FIU has to comply and then pass the information on to the AG. Now, I am taking an approach, Madam Speaker, that there's a presumption of regularity in the acts of public officials. So I'm not casting any aspersions in the office of the AG. But I think this approach really, in the context of counterterrorism measures, places the office of the Attorney General in an invidious position. Too much power is being vested into the hands of the AG without any mechanisms for accountability on the use of his powers. So I think that at a philosophical level, and this was done by one of the Muslim organizations, when they presented before the committee for my reading, they went into the whole question of the separation of powers, and they gave a whole history, reflective of that. I think it's Kristen Williams and that grouping, Concerned Muslims. So, Madam Chair, that we feel that in the context of the society, the sensitivities associated with that the amendment proffered by the leader of the opposition is a better approach than one where we vest this significant increase of powers in the hands of the Attorney General.
Member for Superior.
There are two aspects. My colleagues have raised one part of it, so I need not repeat those arguments. But there's a further aspect to this particular amendment. What the government is proposing is to delete the following words: furnishing the Attorney General with, this is the FIU, furnishing the Attorney General with information required to facilitate an application under Section 22B and Section 37 spontaneously, and I'm not sure what that means, or upon request. This is what we have been asked to agree to. What was the existing law is the FIU furnishing the AG with information required to facilitate an application under Section 22B, and these are the instructive words, where a designated entity has funds in Trinidad and Tobago. So there are two things happening. One, the AG was getting the information, but not on request. The AG did FIU to furnish them to make application under 22B, where a designated entity. We have now removed designated entity in the government's amendment. So that means it's not only the foreign designations, it's that any person in Trinidad and Tobago will now fall within this proposed amendment. It means that spontaneously, and I'll be happy to get an explanation of what does spontaneously mean, that it should go to the AG, because right now, where the FIU finds suspicious transactions and so on, these are referred to the FIB, the Financial Investigating Bureau, which is under the TTPS. They go there. Why are we now wanting to give such kinds of information to the AG, one? And why are we extending this now, not to just designated ones, but to anybody? So I may get up one morning, not this AG, it may be another AG. Any AG getting this kind of power could get up and say, I don't like the member for Laventille West, and ask the FIU to please forward me information, because I want to make an application under 22 and what was the other one, 37. I want to make those applications. So it is a sharp instrument being used for political appointee to obtain information about every person's private business. And this is why we are suggesting, should you want to have such a power, the designated competent officer should be the Director of Public Prosecutions, who has an insulated role and a more independent role. Some may say, well, the DPP is also biased, or the Commissioner of Police is biased, and so on. But that is the insulated office. On the argument about civil versus criminal and so on, I fail to see the distinction, because when you look at what these proceedings are going to be about, they are for you to go eventually to exercise, to charge criminal. You're not just going to get this information. You're going to say this person has committed a criminal act, so I'm going on the 22B to freeze and to list you as a terrorist. That cannot be civil. It cannot be. These are things that would lead to criminal charges. And already we have the DPP in roles such as these in other jurisdictions which are very similar to ours. That will be Antigua, Barbados, Jamaica, St. Lucia. Those points become more relevant when we come to 26 and 20, the next clause, 27 and 28. But it impacts on why we are suggesting the DPP be inserted at this stage as well. So here we are, an Attorney General at large, being given a power to request information on any person. That is a very dangerous provision, whether it is this AG, this government, another AG, or another government. We pass the law for anyone. You're making a provision here that can be totally abused for reasons that are not justifiable, for nefarious reasons. We're giving these kinds of powers. They can be abused in a manner against a citizen. So an Attorney General may not be the one from San Fernando West, might decide that the member for Diego Martin Northeast. I want him out of this business, because he looks like he's really going to be the next Prime Minister. He already has acted how many times? 20 times.
Hungry for power.
And yes, and therefore the Honourable Attorney General, any Attorney General, may say, I want all that person's information, Diego Martin, Northeast. I want all of it. The potential for abuse is tremendous. So first you wind the remit. If you want to keep it as the existing law, you keep it for designated entities. You do not have it then for persons from Trinidad and Tobago, the designated ones from abroad, where they have a different kind of process. And this provision, and we'll come to the other two after 27, 20. It's like we are creating a Department of Justice and Homeland Security all in one person, in one office. Madam, we have serious objections. The other clauses, we've raised amendments, accepted and so on, but these three coming down with the insertion of the AG in these ways, with these powerful powers, but dangerous powers, we have very, very serious objections.
Yeah.
Member for Port of Spain, North St. Anne's West.
Thank you. Thank you very much, Madam Chair. Madam Chair, I think it's necessary to bring this all back into context. First of all, as every lawyer would know, and as I'm sure the member for Siparia would know as well, the supreme law is the Constitution. The Constitution states, as the Attorney General has said, as 76.2, the Attorney General shall, subject to Section 79, be responsible for the administration of legal affairs in Trinidad and Tobago, and legal proceedings for and against the state shall be taken, A, in the case of civil proceedings, which we're talking about, in the name of the Attorney General. So the first point is the supreme law has placed that responsibility solely, squarely, and only in the office of the Attorney General. Civil proceedings, and that's what we're discussing here. It's all about civil proceedings here. The next point to be made is that the Attorney General also plays an international quasi role in the mutual legal assistance matters and is the central authority. This is where all sovereign states that we have international treaties with any criminal inquiries, etc., that they need to make for the purposes of evidence, they go straight to the Attorney General in a process similar to this. And then another point that seems to be escaping is all that is required in Trinidad and Tobago to form a cabinet is a Prime Minister and an Attorney General. So when the Constitution and the framers of the Constitution and all of us have abided by the Constitution up to this point, see that this is such an important office and so much responsibility resides in this office. And let us add as well, Madam Speaker, Chairman, the common law that places the burden on the Attorney General of protecting the public interest and the public's rights. There is no other office, I respectfully submit, Madam Chair, that can carry this out. It is not for the Director of Public Prosecutions. In fact, to put the Director of Public Prosecutions there, you're putting him into a potential conflict situation. Because ultimately, the Director of Public Prosecutions is the person who is going to be charged with the responsibility to prosecute criminal matters. And that is why it is framed this way, that he stays out of civil matters.
All right. Attorney General, and then I'll take member for St. Augustine.
Thank you, Madam Chair. I thank my learned colleague for Port of Spain North, St. Anne's West. Perhaps he could have gone a little bit further to actually read the provisions of Section 90 of the Constitution, because it's in Section 90 of the Constitution that the DPP is vested squarely with the role that the DPP exercises. Now, the reason why I'm jumping in now is that the length of reply will become too long and I will lose the focus. So I thank you for allowing me to treat with this. I want to treat with the member for Chaguanas West. We're now being told, and the language that my learned colleagues are suggesting is that this is somehow a new power. And the argument is hinged because Section 22AA is being posited as being, okay, before it was just designated entity, and designated entity was just what the UN SCR dealt with, and that's okay. Now we're asking for anything, and what does spontaneous mean? That's the nutshell of the argument. Let me start with this. Law must be read in the context of the whole of the law. That's the first and most important provision. The existing power in the law, as it stands without any amendment, exists in Sections 25(3), Section 33, Section 32, Section 37. For the record, the UN SCR and the UN rules via UN SCR 1373, which is now the law, and which my learned colleagues opposite brought into law 2011, 2012, 2014, 2015, my learned colleagues opposite brought to life UN SCR 1373, which says that you must treat with more than designated entities. So my friends opposite moved the Parliament on 4 occasions, fattened the powers of the Attorney General, who conducts civil litigation. The PNM opposition had nothing to say against that, because obviously we're aware of the Constitution, Section 76(2), Section 90, and the provisions of Section 25(3), 32, and 33, and 37 of the existing law. So we wouldn't have dared to raise the specter that the Attorney General was the improper creature. So I want to start by saying that that proposition, it's remarkable that it's being made, because the recentness of this argument belies the fact that my learned colleagues opposite sat on this law and improved it on 4 occasions when they were in government. And there was no difficulty with Attorney General Ram Logan or Attorney General Gavin Nicholas acting in this capacity. And this is not a matter of additional powers. Let's put it this way. Section 25 of the existing law provides specifically for the following. 25(3), where the Attorney General receives information that there may be present in Trinidad and Tobago a person who is alleged to have committed an offense, the Attorney General shall cause an investigation to be carried out. 32, disclosure and sharing of information. Every person or regulatory authority who has any information which will assist in preventing terrorism, securing arrest, person of an offense under this act, shall forthwith disclose the information to a police officer or the central authority. The central authority under the Mutual Assistance in Criminal Matters Act is defined as the Attorney General of Trinidad and Tobago and has been the law for umpteen years. Let's go further. The regulatory authority as defined in the existing law in Section 32 says that it must be the regulatory authority means Central Bank, the Securities Exchange Commission, the FIU. It's right there. The FIU must tell the Attorney General under Section 32 exactly what my learned friends are saying is now a recent power. That's been the law since 2005. 2010, when we included the new Part 3A, the amendments in 2011, 2012, 2014, 2015, brought by Brigadier John Sandy, brought by Anand Ram Logan, brought by Larry Hawaii. Madam Speaker, I am genuinely in shock at the argument being put now. Let's go further. Section 33 and Section 32 make it an offense for the FIU not to provide the information. Let's go further. Mutual Assistance in Criminal Matters Act under extradition. The Attorney General, acting as central authority there, receives particulars of charges and evidence. That has been the law for umpteen years. The Attorney General, as existed under the UNC or the PNM, has that privilege and power. And I want to raise something. We have seen that in notorious extradition matters, where the Attorney General receives information. I, as Attorney General, have a massive amount of information of criminal matters under the MLAT provisions in the Mutual Assistance in Criminal Matters Act. But, Madam Speaker, let's go further. No. You see, my learned colleagues opposite are saying now, I'm coming for you, draconian power. And what I'm saying, Madam Speaker, is that that is to make a mockery of the existing law. The existing law provides for all of this. And this has been the written black and white version of the law for umpteen years. So, Madam Speaker, let's go further to answer the arguments. My learned colleagues are saying, what is meant by spontaneous? Perhaps spontaneous can be put to the words of its own volition. It could easily be so because we did it when we amended under the miscellaneous provisions legislation under the power of the FIU to engage ex proprio motu spontaneously of its own volition information to other FSRBs, FATF-style regional bodies. We put that power into the FIU. So there is precedent for that. My learned colleagues say, let's have the DPP and call Antigua and Barbuda. Antigua and Barbuda uses the Attorney General. Bahamas uses the Attorney General. Canada uses the Minister of Foreign Affairs. I'm wrong? Permit me. Madam Speaker, I brought the law. I have the law. I have it printed right here with me. I've done a trawl for the entire Commonwealth and can demonstrate where elsewhere in the Commonwealth, attorneys general or elected members, let's put it that way, elected members, executive members who can possibly engage in acts of surreptitious nature, political activities, where attorneys general have the existing power in the Commonwealth to do this. So, my learned friends opposite now, in summary, can have their argument answered as follows. This has been the law, that the Attorney General functions under the Constitution under Section 76(2) since independence. Secondly, the DPP's powers are set out in our written Constitution since independence. Thirdly, the Mutual Assistance in Criminal Matters Act, which is a law which predates this Anti-Terrorism Act, has the Attorney General involved in what they, on the other side, call a blurring of lines, because the Attorney General is involved in the criminal end of those equations under MLATs. Fourthly, the Anti-Terrorism Act was birthed in 2005, amended in 2010, 2011, 2012, 2014, 2015. The civil power which exists under that law is vested in the Attorney General and has been, and if it was good enough for my friends for the whole 5 years and 3 months that they were in power, it surely has to still be good enough for us. The next position is that the UNSCR regulations and resolutions have evolved. Specifically, UNSCR 1373 requires the government of Trinidad and Tobago and every entity that is a member of the United Nations to act in respect of individuals. And therefore, the need to amend Section 22AA in the fashion that we have has arisen because of the evolution of the UNSCR positions. Further, Madam Speaker, It is in specific reliance upon recommendation 6 of the FATF 40 regulations and 10 immediate outcomes that we are obliged to treat with this recommendation. Madam Speaker, the government has to draw a line on this particular position. We cannot accept this recent argument. It is an inexplicable argument. And if the argument is accepted, it may require us to amend the Constitution, specifically for the powers of the DPP. Secondly, we would then have to remove the Attorney General acting in habeas corpus matters, etc., on the civil side. So it'll just require a complete removal of the Attorney General. And for the member for Siparia who held the office of the Attorney General herself, for however short that period was, to volunteer this argument today. As much as I've tried to be respectful in my advocacy for this bill, I am compelled to point out now for all of Trinidad and Tobago that I fear that we are playing politics with nonsense. And Madam Speaker, the government cannot and will not accept these amendments being proposed.
Member for St. Augustine.
Thank you very much. Madam Speaker, Chairman, let me just say, having heard the passionate version of the argument from the Attorney General, I think we need to refocus here. I too had some disquiet when the matter was first raised in the committee and the Joint Select Committee. But I've heard the Attorney General repeat his arguments. But I think the other side is possibly forgetting that they do not need to convince themselves. They need to convince members on this side to get the necessary votes. And the argument that the Attorney General, and it is quite persuasive, that the Attorney General has been listed in the Constitution and in other legislative changes over the years as the person responsible for dealing with civil aspects of legislation. In this particular case, however, the civil aspect is only the tip of the spear. The other end really is going directly into criminal prosecution. This is about terrorism, and not just about forfeiture of property and that sort of thing. And I want to ensure, as the Attorney General has indicated from the beginning, the importance of this country, that this legislation is passed. But if we cannot reconcile this issue, then I fear it will not be passed. And to suggest that there is no alternative is really to turn away the creativity of the minds of all of members of the Parliament, and to rely on a foundation of a constitution written years ago. Yes, when there is a need for constitutional reform, there is no issue on that point. Could I be permitted? And not to have learned from the experiences of not just the distant past, but the recent past, when Attorney Generals, and not my friend from San Fernando West, I assure you I've known for 20-odd years, interfered in prosecutions. We cannot turn a blind eye to the Basde Pandey prosecution when a sitting Attorney General was directly finger-pointed without consequence to this day. You know, these are issues for us to create an artificial chamber here without any relationship to the real world aspects. It's to undermine the very purpose that we are here. So that if it is, from what my friend has said, the Attorney General is the central authority. Well, if he is the central authority under law, and the application being made for the amendment is to rename it central authority.
It's saying give the DPP.
Hold, I'm not finished. On one aspect, there's an issue of the central authority taking lead in relation to some of the international issues for mutual assistance. And we can go that route because at the end of the day, you could hold your position, others could hold theirs, and then if you are right, Attorney General, and the anti-terrorism law is not passed, if you are true to, and correct in what you've said, then the nation will pay the price for an inability to agree here. And I'm showing a possible path forward And really, in a way, it's really a name change, nothing more than that in substance. The DPP has always had the prosecutorial powers. I would have referenced some of the central authority. There is great cooperation between them. In fact, I could tell you I'm at present involved in a case where there is that coordination. I have seen it live and direct between those two bodies. So I ask you to take a different look at things. Because at the end of the day, if you want to pass this law, you need to convince all of us here. Thank you.
Attorney General.
Madam Chair, if I understand my learned colleague from St. Augustine, the crux of the submission is use the central authority, which is the Attorney General, and have the DPP treat with the matter. Madam Chair, the mischief that my learned colleague from Siparia was attempting to portray was that an Attorney General, an office holder, could ask for information. A politician. So my learned colleague's prescription is let's use the central authority. Madam Chair, it still is the central authority that my learned colleague St. Augustine just raised, and then have the DPP treat. I want to put it into context. The central authority is the Attorney General. So, relabeling it. But Madam Chair, I want to put this squarely on the record. This 22AA says, furnish the AG with relevant material for an application under 22B and 37. When you go to 22B, if the Attorney General is acting, this is the law 2010, 2011, 2012. You'll see it in the marginal notes where the last government gave the then Attorney General all of these powers to act as they say ought not to be done now. So when you look to 22B, there's a formula approach. The Attorney General is asking for this information for the court, not for himself. The listing in 22B is for the court under due process. There's no fishing expedition here. It is this amendment for 22AD is pinned to 22B. And Madam Chair, what my learned colleagues are asking to be done now is to rewrite the Constitution of the Republic of Trinidad and Tobago. To remove the Attorney General's express power, to remove the Attorney General's locus standi to handle civil aspects, because the listing is in a high court civil jurisdiction, and to put the DPP, who is not vested with that civil responsibility and jurisdiction. So are we going to agree here today to a 3/4 majority or 2/3 majority to amend the Constitution? Is that what the opposition is saying? Madam Speaker, my learned friend for St. Augustine was correct. You can lead a horse to water. You can't make it drink. The opposition, in a nutshell, is saying, remove the Attorney General. This is a dangerous position. They are asking Trinidad and Tobago to ignore the fact that it has been the law, anti-terrorism law has existed since 2005, that in 2010, 2011, 2012, and 2014, the UNC Attorney General had this power. And they are now saying, you are in opposition, and you now say to the government, you need our votes, amend the law. That's what you're saying. You are saying to Trinidad and Tobago, which is being blacklisted, which is on the brink of disaster as it relates to the implementation of this law, you're saying it's my way or the highway. Change the law and change the Constitution and remove the Attorney General from its position. That is called blackmail. That is called blackmail. I take that back. That is called I withdraw the word blackmail. I'm upset. That is called unreasonable at the best.
Word blackmail, I'm considering it unparliamentary. The Attorney General has withdrawn it. We're not going down that road again. Please. Member for Laventille West, then Caroni Central, Point up here, Naparima.
Thank you very warmly, Madam Chairman. Madam Chairman, when the Attorney General, after making his rather persuasive and compelling arguments for the maintenance of the amendment that is in front of us, when he was through with that, he put the member for Siparia, I would like her to member for Siparia. Yes. So that when the Attorney General suggested that they're effectively suggesting that the authority and the office of the Attorney General is removed from the equation, they all shouted, no, that is not what they want. So I'm accepting that at face value. The question is, the amendment says that the Attorney General should be furnished with all relevant information, not information that is not relevant. And the term relevant pertains to relevant information to proceeding civilly in the forfeiture provisions of the bill. So the information that the Attorney General is to receive must be relevant, meaning it is to be limited to the conduct of the civil proceedings, which is in the domain of and the authority of the Office of the Attorney General. So the question for the member for Siparia is this, or for my friends on the other side, is it that they believe that the Attorney General should not get information that is relevant to conduct the civil proceedings that he must against persons who are in the focus of this law? That is the question. And therefore, Madam Chair, even if the recommendation, as the member for Siparia has put, is that the information should go to the DPP, when the DPP receives information, he is going to be treated with the criminal side of all of this. But if there is information that supports the civil regime, is the DPP then to send it to the Attorney General, or what does he do with it? So if there's information available to assist the state against terrorists,
information doing clause 26, we're doing 26. It doesn't deal with central authority. It doesn't deal with what?
No, I'm talking about
clause 27,
members,
madam.
Everybody cannot speak at the same time. All right?
I find
Overrule, member for Laventille.
Yes.
You have one more minute.
Thank you
to
very
just
much.
wind up,
So I'm
and
winding
then-
up, Madam Chair, to say that the amendment as proposed requires relevant information to pursue the civil side, and wherever it comes from, if it is available, it ought to be in the presence of at the hand of the Attorney General. So therefore, I support the amendment that's put by the Attorney General and reject the suggestion that is being made by the member for Siparia.
Member for Caroni
Thank
Central.
You. Much, Madam Chair. The Attorney General, well, first of all, I want to say the objective is neither to rewrite the Constitution nor to alter the significant role of the Attorney General under the Constitution of Trinidad and Tobago. I want to say that from the outset. But the Attorney General spoke with a lot of passion, but in doing so, he also is moving in a direction of really, with his arguments, personalizing the issue and then secondly, politicizing it. I would suggest that we do not either personalize or politicize it further. I think that the Attorney General, in outlining the powers he now has under the law, in fact made the case that the existing powers of the Attorney General are sufficient to deal with all the matters under this particular bill. And therefore, there is no need, really, to make alterations that affect the relationship of the Attorney General with the DPP, with the Commissioner of Police, or with the FIU and the other regulatory authorities. And therefore, if the Attorney General finds it objectionable that the Director of Public Prosecutions would now be handed another or an additional mandate, which would detract from the role of the Attorney General, I would suggest that the Attorney General proceed in a way which acknowledges the powers that he now has under existing law, delete the section out, because the three offending sections have to do precisely with the issues that I raised. That is to say, the DPP, the Commissioner of Police, and the FIU. And under the existing law, with a deletion of what you have now, I think that it would be reasonable to proceed with this terrorism bill.
Madam Chair.
Attorney General, could you just hold a while? If you could hold a while, let's just hear point of pair and Aparima, and then I'll call upon you.
Thank you, Madam Chair. Attorney General, I understand the passion that you exuded a while ago.
Madam Chair, I'm sorry, just for one moment. I do respect that you wish to do a response in the round, but it is not apposite respectfully if I could ask you to reconsider, because the points raised individually are very deep, Madam Chair, and I don't want to be passing through on a very important observation that my learned colleague did. So if I could crave your indulgence to respond to my learned colleague, because I think it's dangerous if I don't get to the depth of it. And I'm being urged by the Honourable Prime Minister to ask for your attention on this.
The only difficulty with that is that if I allow a response on every contribution, it may not work for time, efficiency.
Understood. I don't propose everyone, Madam Chair.
Okay? So that I will allow you on this one, but I would say to you, after this, point of pair and Naparima we will take.
Sure.
And then you will do your contribution.
Thank you. Madam Chair, the constitutional law of this country must be considered for what it is. Our 1976 Constitution, by which we moved beyond independence and became a republic, saw Section 90 of the Constitution, which treats with the DPP's position, put into law. I must put it on the record. The DPP, at Section 90, says, the Director of Public Prosecutions, the provisions of this section have effect with respect to conduct of prosecutions. There shall be a Director of Public Prosecutions whose office shall be public. The DPP shall have power in which he considers it appropriate to do to institute and undertake criminal proceedings, to take over and continue any such criminal proceedings, to discontinue at any stage before judgment criminal proceedings. Powers of the DPP vested in him to the exclusion of others, etc. The Barbados situation and other territories are at independent stage. They are not republican constitutions. And it's very important to note that under the independence constitutions, like Antigua, like Barbados, the Attorney General has the power to direct the DPP. So the independence constitutions allow for the office holder, executive, politician, Attorney General to direct the DPP under their constitution. Our 1976 Constitution separated the DPP and the Attorney General.
That's the whole point.
And the criminal jurisdiction that the DPP has must be separate from the civil jurisdiction which the Attorney General has. And it is for that reason that our anti-terrorism law uses its Attorney General, qua central authority at times, and the DPP. And the two do not mix. We are entering into a very dangerous realm of constitutional confusion, Madam Chair, because it sounds good, you know. It sounds good. Let's not have a politician involved. But the constitutional parameters of our 76 Constitution must be factored here. This is no trivial game. It's why the law has stood that way from 2005 to 2018. And I'm urging my learned colleagues, I am on my figurative knees, asking you to please treat with this within the parameters of reason.
Chair,
All right, member for Carney, I'll take you after if you wish.
completely misinterpreted what I said.
Okay. Member for Pointe-a-Pierre.
Told him that the
Member for
AG stands on the existing law.
Member for Carney Central, I'm sure we all understood. Member for Naparima, I believe you have vacated. So member for Pointe-a-Pierre, and then we'll have member for Superior.
Okay, thank you, Madam Chair. Attorney General, let me just try and bring back something in there. First of all, this is not about the central authority in this clause, all right, or whether we're trying to figure it is relevant. The question I would like to ask and pose is that you have looked at our amendment and you don't agree with the amendment, and I am asking you. No, let me just now, you'll answer.
Proposing something else.
The original parent law in D states, furnishing the Attorney General with information required to facilitate an application under Section 22B, where a designated entity has funds in Trinidad and Tobago. And so that was struck off in the Joint Select Committee. You had a change. And your change is furnishing the Attorney General with information required to facilitate an application under Section 22B and Section 37 spontaneously or upon request. And now we are saying that if you don't agree with our amendment, why not go back to the original parent law? Because we feel that the amendment that was done has given the Attorney General, not member for San Fernando West, too much powers given the parameters, right? And we feel that if you can't, why not consider going back to the original parent law, or even was there a change in the first place to give the Attorney General that amount of power?
A very good pointed question. I thank my colleague for it. The answer is squarely found in UNSCR 1373. What does that mean? The United Nations Security Council Resolution 1373 requires us and all other jurisdictions to act beyond designated entities. It requires us to act for individuals and listed entities. The FATF methodology, which the UNC government agreed to in 2015, in fact in 2012, twice, 2013, and then 2015, committed us to agree to more than just designated entities. So this government is perfecting what you agreed, that UNSCR 1373, as applied by FATF methodology, as we've been rated in our fourth round mutual evaluation, it says that we must treat with more than just designated entities. Secondly, if the power exists elsewhere, as I have demonstrated by reading it out, what could the harm be in stating it positively? Because it exists in 25.3, 32, 33, 37. And as I see Senator Hussain pulling up 1733, I'll tell him, look for the FATF methodology, joint group review. You will not find it in 1373 alone. It is not just you pull out and you say, aha, the methodology in the fourth round mutual evaluation has been set out. This is not a simple position, and it can't be dealt with off the cuff. We have been told that this must be dealt with. We discussed it in the Joint Select Committee. The power exists elsewhere. Are we just asking us to revert to quote-unquote what was there? If I revert to just designated entities, I fail Section 6, Recommendation 6. Trinidad and Tobago fails Recommendation 6. The whole country fails because it would only have treated with designated entities. Secondly, it exists in the other laws. So that's the rationale, and that's why the insistence is that the FIU provide information within very specific parameters, only for listing under 22B and only for forfeiture after listing under Section 37.
I seek just clarification, Chair. To the Attorney General, I as an individual have a concern that my name could end up, not by San Fernando West, by Attorney General, asking to seek information on point of view.
Sure.
That's a real concern that I have. And based on what you're asking us to approve, is given that individual that power. How do you satisfy me
Sure,
that
but
I
point of
would
view, may I
not?
ask you, what is the effect of sections 32, 33, 37, and 25.3? Is it true that the Attorney General can demand that information right now under the existing law? Yes or no?
No, you tell me.
Yes.
Then keep it.
I've read it out. Why do I need to amend this provision? That's the square question. I'm not increasing power. I'm moving beyond designated entities, which I must do to meet recommendation 6. Who got me to agree to recommendation 6? The UNC government. I didn't ask for it. I did not put Trinidad and Tobago first into the 4th round mutual evaluation. Anand Ramlogan and the cabinet of the UNC government agreed to that.
Member for Superior, do you still wish to make the contribution?
Thank you very much. Just a few points, and I think we can allow the AG to wind up on this particular.
I'm sorry to interrupt. 6.5b, recommendation 6 from FATF. The obligation to freeze should extend to 1, all funds or other assets that are owned or controlled by the designated person or entity, and not just those that can be tied to a particular terrorist plot, threat, etc. 2, those funds or other assets that are wholly or jointly or other controlled, directly, etc., by designated persons or entities. That's recommendation 6.5 bis.
Sure. Sure. Okay, so you're justifying changing it to everybody and not just designated entities. But can you point to me anywhere in the FATF or in that resolution, because it is my respectful view, that there is nowhere that the FATF or the UN said that the AG must be the designated person. There is nowhere where it says that. That's my
Correct,
first point.
because each jurisdiction must
Secondly,
apply its own law. Sorry,
yes,
please proceed.
So where it is that you are really granting to yourself what we see as increased powers, and you say you have to give increased powers, we are saying that the competent person should be the independent office of the DPP. So there is nothing that says that the Attorney General must be. Correct. Must be the functionary.
Yes,
it
there
says
is.
we must do all these things. We must do all these things which we are attempting to do, but nowhere have I seen that, and if you can show me.
Yes,
and
I
this
can.
distinction now, this distinction between civil and criminal and Section 90 and so on. Section 90, again, you have an interpretation, I have my own. My respectful interpretation of Section 90, giving powers to the DPP, that is in respect of bringing proceedings on the civil side in the name of the AG, in the name of, and in the criminal side, in the name of the DPP or the state.
Sure.
So I'm not sure that that applies. But right now, in this bill, madam, we have the DPP exercising functions in this bill.
For what purpose?
The AG read it out to us. Well, you know, you have the DPP. You're inserting the AG into other things. It's like a kalulu or a pilau. You have the DPP doing some, the AG doing some. I feel that this can be consistent and harmonized if we have one office, and we're thinking, as we said, in these cases in 26, and I believe 27, to have the DPP. And the other point, madam, is right now under the Proceeds of Crime Act, and prior to the Proceeds of Crime Act, was the Dangerous Drugs Act, where the DPP was given these same powers of forfeiture from the Dangerous Drugs Act. Yes, the point is given, he has the power
In which
to
jurisdiction?
Go in Trinidad and Tobago.
In which jurisdiction? In the
Trinidad
criminal
and Tobago.
jurisdiction?
He has the power to go for forfeiture. If you're saying forfeiture and freezing orders are civil, he can apply to a court under the proceeds of
Sorry, would you just expand that for a moment?
DPP. Yes, under the proceeds. You know,
No, please continue. Please continue.
Whilst I'm speaking, I'll get the sections for you. Huh? If you can ask them to pass me. Under the Proceeds of Crime Act, prior to the Proceeds of Crime Act, we had something called a Dangerous Drugs Act.
Still have it.
Yes, but that was amended. And all these provisions for forfeiture and freezing and so on, they were removed and they were placed under the Proceeds of Crime Act. So it was there from before, or with the dangerous drugs. So the DPP has had powers within our jurisdiction to apply for what you are calling these civil orders, the forfeiture and confiscation, freezing and so on.
No,
So-
not civil orders.
No,
me take
please,
my
can
mic.
I finish? You got to answer, sir. I say again, the opposition is very concerned with increasing the powers under the office of the AG. Our office of the AG, and you're very clear to tell me in other jurisdictions what they could do and cannot do. Here, we don't have a Department of Justice, we don't have a Homeland Security. And these, with 26, 27, 28, is creating this mega ministry of the Attorney General with these very draconian and invasive powers, and we on this side say we have a grave difficulty in accepting. The other amendments we dealt with, some we agreed some, but we have a grave difficulty with this, madam, and I rest my case as that as the final submission on our side, yes?
Madam
You
Chair?
okay? Yes.
The government is in the following position. The honorable member for Siparia referred to the creation of a hodgepodge, DPP, Attorney General, Central Authority.
Which section?
Let's put this squarely into context. That was created in the year 2005. In 2010, it was improved. In 2011, it was improved. In 2012, 2014, and 2015, that so-called hodgepodge was amplified and improved by my learned colleague as the Prime Minister of Trinidad and Tobago, as Siparia then was. Secondly, where in the law does FATF say this? My learned colleague asked squarely. FATF, in prescribing methodology for 190 jurisdictions, which are common law and civil law jurisdictions, could never say use X office holder. It would be absurd for them to do that. So what they do is to prescribe a methodology which is then translated into local law by applying your relevant legal system. In Trinidad and Tobago, what says that the Attorney General must do this is the same thing that said so in 2005. It's the same thing that said it in 2010, 11, 12, 14, and 15. And you know what that is, Madam Chair? It's called the Written Republican Constitution of Trinidad and Tobago. There is no proceeding in Trinidad and Tobago that I am aware of that the DPP has engaged in on the civil side. None. The DPP is constitutionally incapable of launching civil proceedings. Constitutionally incapable. Secondly, the Proceeds of Crime Act, specifically allows for forfeiture provisions. As I recall, Section 38 of the Proceeds of Crime Act allows for forfeiture provisions in criminal proceedings after a predicate crime has been proved and a conviction has been given. So let me make this abundantly clear to my learned friend. The DPP cannot engage in civil action under our Constitution. There is no example in our laws where that can happen. Only the Attorney General, pursuant to Section 76(2), has that locus standi. Only the Attorney General. The forfeiture provisions under Section 38 of the POCA Proceeds of Crime Act are in criminal proceedings where a conviction has been obtained and a forfeiture can happen. There is a halfway position for forfeiture provisions in another circumstance in the criminal division where conviction may not be had. And that's where the cash seizure forfeitures happen. Those are the only two ways that forfeitures happen. So let's be real. Let's be legal. Let's be lawful. There is no way that a DPP can engage in the civil realm on this point. Our Republican Constitution does not allow that. I have answered squarely the position as to why we are moving beyond the designated entity, UNSCR 1373, recommendation 6.5 and 6.5 bis, as I recall, if I've got the FATF terminology correct. That says that you must move beyond designated entity to entity and individuals. The goalposts have moved. Who committed us to this process? Siparia, Anand Ramlogan. Anand Ramlogan, as Attorney General for Trinidad and Tobago, the Honorable Attorney General, sat as the Deputy Chair of the Caribbean Financial Action Task Force. A.G. Ramlogan was the Deputy Chair of the Caribbean Financial Action Task Force. Listen, I'm dealing with the law here. So, Madam Speaker, what my learned colleagues are proposing is constitutionally incapable of success. I'm confident my learned colleagues will now be reminded of that if it wasn't known before. The provision of forfeiture by the DPP under the Dangerous Drugs Act, as it was assumed and subsumed by the Proceeds of Crime Act amendments, is only in the criminal jurisdiction after conviction and for cash forfeiture. I'm absolutely sure about that. So my learned friends respectfully have not advanced a case which can hold water. And I am asking my learned colleagues, I am pleading with my learned colleagues opposite to recognize the truth of what I'm saying. Our country is looking at us. We need your support. And that is the government's position.
Member Faruqa Maloney.
Speaker, Madam Chairman. Madam Chairman, I just wanted to support everything that the Attorney General said, but I just wanted to put one other thing into the mix, which takes off from what St. Augustine said in relation to an Attorney General being the cause of Bastille Pandey being sent to prison. And I really think it is beneath the dignity of the House that any member of this House will make that argument that an Attorney General will go after a political opponent. And I really think that that should not stand in the records of this House. And I would also like to indicate that it is a highly improper claim to make. And I would also like to indicate that that claim, which is now also being put on this Attorney General as part of what this government may possibly do, needs to be totally rejected, not only by us on this side, but by this House of Representatives. Thank you very kindly, Madam Speaker.
So, members, the question is that clause 26 be amended as follows. In terms of the amendment, one as proposed by the opposition. Those in favor say aye. This is in terms of the amendment as proposed by the opposition. Okay. Those in favor say aye. Aye. Those against say no. No. Division, please. I think the noes have it. Okay, so you're about to take the division, so could we have a little order so that the clerk will get this correct?
The whip is lifted, yeah.
Mr. Alwari?
Yes, I reject the motion and I vote no. I reject it.
Dr. Rowley?
Stop.
Yes, I reject the motion and I vote against it.
Mr. Imbert?
No.
Mr. Young?
No.
Mr. Dialsing?
No.
Mr. Hines?
No.
Mr. Ford?
No.
Mr. Mitchell?
No.
Ms. Cujo?
No.
Mr. Garcia?
No.
Mrs. Critchlow-Coburn?
No.
Mrs. Robinson-Regis?
No.
Mr. Dillon?
Nope.
Mrs. Webster-Roy?
No.
Dr. Gadsby-Dolly?
No.
Dr. Francis?
No.
Mrs. Jennings-Smith?
No.
Miss Oliver?
No.
Mr. Answine?
No.
Mr. Leons?
No.
Mr. Smith?
No.
Mr. Lee?
Yes.
Mrs. Basad-Bissasso?
Aye.
Mr. Charles?
Yes.
Dr. Rambachan?
Yes.
Mr. Karam?
Yes.
Dr. Tiwari?
Yes.
Dr. Munilal?
Yes.
Mrs. Nuwalu Hussain?
Yes.
Dr. Gopi Singh? Mrs. Gayadeen Gopi Singh?
Yes.
Mr. Indar Singh?
Yes.
Mr. Ramadan?
Yes.
Dr. Khan?
Yes.
Mr. Padarat?
Yes.
Dr. Budo?
Yes.
Mr. Pari?
Yes.
Ms. Ramdial?
Yes.
Mr. Singh?
Yes.
Honorable members, the result of the division is 17 ayes, 21 against, with no abstentions. The amendment to clause 26 as proposed by the opposition and circulated is not moved. The question is that clause.
Just on a procedural point, I know we are saying that the list of amendments contained in the JSC report, that those don't have to be put for a vote. But how can we object to the amendment that has been proposed in that list, in this particular clause? How can we get to vote on that?
Okay, member for Superior, actually that's what we're voting on.
No, what we are voting on was the amendment put by us.
No. If and let's just understand.
Sure.
Remember, we went from clauses 1 to 4.
Agreed.
Okay? 5 were new amendments or further amendments. Okay? 1 to 4 would be your JSC report bill. And if there were amendments proposed by the JSC, it would have been captured in this. I think what we have are a number of things. We have this, which I think everybody should have. And then we have a separate document that just gives you the highlights that you could look down on. But if you compare that list you're talking about with the document, the version of the bill we have before us, you would see it's incorporated. So we've been voting all the time.
On the red ones, in that consolidated bill.
Yes.
But how do I get to say I do not agree with that?
Well, when we put clause whatever to you,
Yeah. Which is just being done.
well, this one is not a good example because we put further amendments.
I really want to know.
So
what
when
to
we
do.
go to another clause,
No, but how do I get, I want to deal, how do I get for this? It's in the red one, madam, at page 425, 22, double capital A, D, the red there. How do I get to say I don't agree with that?
but didn't we just, isn't that what we're
No,
dealing
ma'am,
with?
we dealt with amendment from.
Right, so I'm now going to
that's gone.
put, right? What is before us is the one that you had originally
My
there
amendment.
in this bill. Then both you and the Attorney General have amendments to it.
Yeah, yeah.
So I've put yours, which was,
Agreed.
I'm now going to put the Attorney General's, right? So when I read the bill originally, as it was, clause, it's then all your discussion would come, including your proposed amendment.
But that's gone, that part of it has gone.
Yes.
How
So you
can
will
I-
know for the next
How can
set
I,
of sections
how
that
can
are
I,
coming.
for this clause 26, indicate that the opposition does not agree with what is inserted in 22AA-D? How can we do that? 22. Yeah, but this was not in the original amendment bill. Well, let me just, for the record, madam, indicate the opposition does not support the red amendments at page 425 into section 22AA.
Yeah.
They do not support it.
Yeah, and I think that was clear from what
How it's read.
your proposal was. All right, your proposed amendment. Okay, so we're now going to deal with, just now, let's just finish this and then we go for. The question is that clause 26 be amended as follows in terms of amendment 1 as proposed by the government and circulated. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that clause 26, as amended, now stand part of the bill. Those in favor say aye.
No, sorry.
Those against say no. Take a division. Stop speaking.
Be accepted. Are you ready for the vote?
Mr. Alwari,
I vote that the government's amendments be accepted, yes.
Dr. Rowley,
Yes.
Mr. Imber,
By all means, absolutely yes.
Mr. Young,
Yes. Oh, look,
Mr. Dialsing, Mr. Ford, Mr. Ford,
Yes.
Mr. Hines,
Yes.
Mr. Mitchell,
Yes.
Ms. Cujo,
Yes.
Mr. Garcia,
Yes.
Mrs. Critchlow Coburn,
Yes.
Mrs. Robinson Regis.
Yes.
Mr. Dillon,
Yes.
Mrs. Webster Roy,
Yes.
Dr. Gatsby Dolly,
Yes.
Dr. Francis,
Yes.
Mrs. Jennings Smith,
Yes.
Miss Oliver,
Yes.
Mr. Antoine,
Yes.
Mr. Leons,
Yes.
Mr. Smith,
Yes.
Mr. Lee,
Yeah, no.
Mrs. Basadbi Sassa,
No.
Mr. Charles,
No.
Dr. Rambachan,
No.
Mr. Karim,
No.
Dr. Tiwari, Dr. Tiwari, Dr. Tiwari, Dr. Munilal,
No.
Mrs. Nuwalu Hussein,
No.
Mrs. Gayadeen Gopi Singh,
No.
Mr. Indar Singh,
No.
Mr. Ramadan,
No.
Dr. Khan,
No.
Mr. Padarat,
No.
Dr. Budo,
No.
Mr. Pari,
No.
Ms. Ramdial,
No.
Mr. Singh.
No.
Honorable members, the result of the division on the amendment to clause 26 as proposed by the government is as follows. 21 ayes, 17 noes, no abstentions. The amendment is therefore carried.
Clause 27.
The question is that clause 27 stand part of the bill. There is an amendment by the member for Superior.
Move the opposition amendments to clause 27, which seeks to deal with section 22B of the bill, of the Act, the Parent Act. Again, it is a similar argument where we are asking to delete the words the Attorney General and substitute the words the Director of Public Prosecutions. Secondly, he shall cause an investigation to be carried out in respect of that allegation and may for that purpose refer the matter to the Commissioner of Police, who shall cause an investigation to be carried out in respect of the individual or entity. We're asking for that to be deleted and to insert thereof that he shall cause an investigation. So this is where the Attorney General receives information. He shall cause an investigation to be carried out in respect of that allegation for that purpose, and as soon as the investigation is completed, provide to the Director of Public Prosecutions a report of the investigation required for the purposes of making an application to list an individual or entity under subsection 1B. Further, to delete the proposed subsection 1A that the AG has, the government has inserted, and in proposed subsection 1B to delete the words the Attorney General and substitute thereof the DPP. Further, in the proposed subsection 3B, by deleting the words the AG, substitute DPP. Again, in subsection 5B, by inserting the words for the word listed, and by inserting after the words entity or the word listed. I think there's been a little difficulty here. We are just speaking of entity, and there's a particular definition for entity, and we feel that this will be more complete because you're now listing people. By amending 6A and propose 6(9)(a), by deleting again the AG wherever it appears, substitute words Director of Public Prosecutions. Madam, our concerns here are again that we are placing too much power in the hands of the Honorable Attorney General or the Office of the Attorney General. We believe that the proper office to carry out these functions should be the DPP and the Commissioner of Police. We face serious concerns where it is the Attorney General refers a matter for investigation to a Commissioner of Police, and that Commissioner now has to send back a report to the AG. I have serious concerns about that as well, where it is, again, the AG said, you know, the AG will not be a fisherman. He will not be on a fishing expedition, but the way it is framed, it creates opportunity for an Attorney General to be a fisherman, to get information about people's private business, and to cause the investigation, first of all, to receive a report from the police. I have nowhere else where a criminal investigation is undertaken and that report is sent to an Attorney General. So I have problems with that. And then thirdly, again, removing the AG, putting the DPP to apply for the listing order and for the freezing orders. Now, some of the points made by the Honorable Attorney General, I repeat again, under the Proceeds of Crime Act, and before when it was under the Dangerous Drugs Act, and I have this section in the law, it was 17-something, because you said it isn't there. I think, if my memory is right, the AG said, look, this is after a criminal prosecution and so on. That's not true. They can go even before to get the freezing orders under the Proceeds of Crime Act. So the arguments there I do not buy, and much of what we said, my colleagues will continue in this vein on 27. Again, the section 90 you're saying is the constraints powers of the DPP and the AG, and if you read it properly, it's for how you bring and carry cases. This is a name, either nominate or on behalf of the AG. That's what that section 90 is. Section 19.6 here, and section 19 of the Proceeds of Crime Act, Chapter 1127. The High Court may, by order, prohibit any person from dealing with realizable property. It's termed a restraint order here. Without prejudice to these, the court may make that restraining order. So you can't deal with your property. It's in effect a freezing order. You can't deal with your own property. And it continues, which one was it, 7? Yeah, a restraint order may be made only on an application by the Director of Public Prosecutions, may be made on the ex parte application to a judge in chambers, and that order may be discharged or varied thereafter. So we again, I feel very strong that the arguments as we have on this 27 will preclude us from agreeing to the amendments to the Anti-Terrorism Act. Yeah.
General.
Thank you, Madam Chair. Madam Chair, my learned colleague started off by saying that we will be giving for the first time, at least that's the way I understood it, the Attorney General will be giving the Attorney General excessive powers. Madam Chair, for the record, the power of the Attorney General to act for listing of entities exists under Section 22B of the current law. That law was brought, the Anti-Terrorism Act, into effect in 2005. By Act number 2 of 2010, that law was amended, Section 22B specifically. By Act number 6 of 2011, that law was again amended. By Act number 14 of 2012, that law was again amended to allow the Attorney General to have amplified powers for listing of entities under 22B. For the record, the mover of the bill, which became Act number 16 of 2011, was Brigadier John Sandy, the United National Congress Minister of National Security under the Prime Ministership of Mrs. Prasad Bisesa. For the record, the mover of the bill, which became Act number 14 of 2012, was Senator the Honorable Anand Ramlogan, acting under the Prime Ministership of the member for Siparia. So that is the law. The Attorney General's power under 22B was good enough to be amended and improved on 2 occasions under the cabinet direction headed by Siparia, the member for Siparia. So this is not a new power in any circumstance at all. So let's get that one straight. Secondly, the recommendation by the opposition is to remove the Attorney General completely and install the DPP. Again, the Constitution of the Republic of Trinidad and Tobago specifically provides that the Attorney General under Section 76(2) is to be the entity dealing with the civil litigation for the state. Section 90 treats with the DPP's criminal jurisdiction, Section 90 of the Constitution. Let's turn to the Proceeds of Crime Act. Under the Proceeds of Crime Act, specifically, Section 38 treats with cash forfeiture.
Stop. If you all could please cooperate with the Attorney General so we can get the points.
Thank you.
Thank you.
Under the Proceeds of Crime Act, Section 38 deals with cash forfeitures. Section 41 deals with forfeiture. And Section 19 deals with freezing orders. All of them are in the criminal jurisdiction or in aid of the criminal jurisdiction of the court, treating with matters where there are charges brought against people. Under Section 22B, the listing requirement does not involve necessarily a charge. For designated entities, so listed under 1267 by the United Nations, you can list. There need not be a charge against ISIS, Boko Haram, Al-Qaeda. There's no need for a charge. Under the listing of entities and individuals, you don't need to get down that realm. So this is why borrowing the support of the Proceeds of Crime Act is to compare camels with ants. It's to compare oranges with watermelons. There is no comparison. What I would ask now squarely to my learned friend for Siparia is, can you explain to me why in 2010, 2011, 2014, 2015, your government was comfortable with the Attorney General having these powers? Please.
The powers therein contained are circumscribed. What you are now doing is you're expanding it. I mean, you have really a whole page amendment in red. So what was there, you like it, it's been there since 05, 10, 16, 18. Keep it. Keep that. But we cannot agree with all these red amendments that you have.
And for the record...
In the bill on the 351.
And for the record, Madam Chair, the Joint Select Committee, in making, quote-unquote, these red amendments, included the Honourable Member for Orapooch East, Dr. Munilal. It included Mr. Prakash Ramada, the member for St. Augustine. It included Senator Saddam Hussein. It included Senator Sophia Choate. Those are non-government members, and they signed unanimously onto these so-called red amendments. They brought the amendments with consent. No minority report was put in. And I cannot, for the benefit of our citizens, do anything other than to urge my learned colleague for Siparia to support that which her own senior members, the Honourable Member for St. Augustine, has acted as Prime Minister of this country. The Honourable Member for Oropuch East, I believe, has also held that distinction. 2 acting prime ministers for Trinidad and Tobago. And the honorable member for Oropuch East is right. He also acted as Attorney General for the Republic of Trinidad and Tobago. So a past Attorney General for the UNC, 2 past acting prime ministers for the UNC, sitting in the Joint Select Committee, unanimously agreed to this so-called red amendments that Siparia has described them as. And I'm asking Siparia genuinely to please reconsider the opposition's approach on this.
Member for Oropuch East.
Thank you very much, Madam Chair. This is really a most appropriate time for me to intervene. And I thank the Attorney General for acknowledging my service to this country. I never dismantled bombs, but I did act as Prime Minister and Foreign Affairs Minister and Attorney General as well. Madam Speaker, let me make the point because I knew this juncture would come. I knew exactly that this juncture would come. In fact, I raised this matter with my colleagues. A Joint Select Committee operates in a certain context. The government, by definition, has a majority in a Joint Select Committee. In the Parliament, the government does not have, at this time, a special majority. It's all these matters, in fact, as I said before, not almost, I think every single matter were raised in the Joint Select Committee concerning these very issues. The Attorney General gave some of that explanation, not all, I think, but some explanation he gave at that time. We proceeded, but these issues were raised. They are not new issues. The Parliament job is not to rubber stamp a report of a Joint Select Committee, but to consider the report because there are rules that even prevent members on a Joint Select Committee from speaking to their own colleagues and discussing. So, colleagues, this is not a report of the opposition. This is a report of a Joint Select Committee. And this is why even the Attorney General, when he came today, made further amendments. Made further amendments that were not the subject of the Joint Select Committee. There were amendments put forward today and is winding up that was not the subject of the Joint Select Committee. Orally, in fact, did not commit to writing, but there are amendments on both sides. So, Madam...
Oh, all right, so maybe have some order, please.
This amendment as well, I believe. So that I don't think it helps us to go to the Joint Select Committee and who was there and who agreed and who did not agree. The purpose of the House is to agree to a report, either with or without amendments, and that's precisely what we are doing here. There is a troubling issue that we have been discussing for some time now, and I'll ask the Attorney General again to remember that this is not a personal attack on the member for San Fernando West. In fact, it may have little or nothing to do with the member for San Fernando West. This has to do with a much broader issue of our deep concern over the powers of an Attorney General in our political structure. If it is that those powers were there before, as you claim, since 2005 or thereabout, and the Partnership Administration presided over that or even amended and so on, well then precisely leave those powers as they are and go no further and pass your bill. We have said that now about 25 times. Now, the other troubling question is this question over the DPP and the Attorney General. We do not have a law library at our disposal at this exact moment. The Attorney General, by definition, has greater support. He has the support of his ministry and the government that he can check things. But, Mr. Attorney General, you are stating categorically that there are no circumstances known to you or the government where the DPP has applied for orders, confiscation orders or other orders, freezing orders in a civil court or to a civil judge. Has said that categorically. We would just like to clarify that that is indeed so. If were there circumstances involving the Ramdani issue in which there were orders made to a civil judge or in the civil court, we'll just like to clarify that because we are not here to quarrel over things that we may not have the research material over, but to confirm, we'd just like you to confirm that to your knowledge, whether it's breaking the law or not, that the DPP has never gone to a civil judge or in civil court over any orders before prosecution as well. If you can check that first. The other matter is the Office of the Attorney General. While this Attorney General may mean well, and have the best of intentions in the world. And I know there are colleagues on this side who may believe that. There are some colleagues who may believe that. The issue is not the conduct of the Attorney General, but in our recent past, you will recall in the extradition matter involving Mr. Jack Warner, I believe it was the first time a foreign jurisdiction, it was the United States of America, I believe, went to the court to get an order or to get the court approval to represent themselves. They actually went to the court. They told the court that they had no confidence in the central authority, and the central authority, as we now know, is the Attorney General. They had no confidence in that office to represent them, and they made an application to represent themselves. It was the first time a foreign state ever made an application for the central authority not to represent them. Again, it had nothing to do with the member for San Fernando West. It had to do clearly with their lack of confidence in that office, maybe other systemic problems or structural issues and so on, we don't know. So we ought not to be living in a paradise and in a dream world to think that in theory, as the Attorney General say, he's not on a witch hunt, he's not there for revenge, he's not what, fishing? He's not a fisherman out in the sea and so on. That is fine, and that sounds good in theory, and all members can declare themselves that way. But in practice, we have had serious challenges with the Office of the Attorney General. The member for Aruka Maloney spoke earlier and took umbrage to the member for St. Augustine raising a matter involving a former Attorney General. But the fact is we have had problems over the years with that office and office holders, not this Attorney General at all. But I don't want to say yet. But
and I advise you not to say.
And I would, yeah, Madam Speaker, I take your advice on that one. But the member for Aruka Maloney, I imagine, in this very parliament, purported to read a search warrant of which she never had in her possession. So what I'm saying is that the office has been a troubling one. It has nothing to do with the Attorney General in this case, the person, and you must take it in that light. If we are to build consensus and get to an end point, we can't see it as a personal attack or as anything against you individually.
Attorney General.
I thank my learned colleague for Oropuch East, and I do take his words in the manner that he has offered them. Madam Chair, if I can address, in the Ramdani case, there was civil aid to proceedings, which were in the criminal arena. So that's a fact. The distinction that I ask the honourable members to consider is that the recommendation coming from the opposition is substitute entirely the Attorney General with the DPP. And that's different from a civil aid function to criminal matter. Secondly, for the record, in the United States matter concerning Jack Warner, just to address the point, because the case involves an argument that there's a conflict between the treaty provisions and the act, this Attorney General, I instructed that the team be cleaved because there could be a conflict of positions between the treaty obligations and the act. And it was for only that reason that we cleaved the representation, because that was a very novel argument, which in fact the Attorney General won in the first round of positions. So there is no position that the Attorney General, this Attorney General, has for the first time been the victim of some history where the US has said, we don't want you involved. That's not the case. The case is that because of the claim brought, the representation was cleaved. And that's the best in practice position. But my learned colleague, I think, may have brought our debate back into center line. I just heard the honourable member for Oropuch say, and I lean to discuss it with the relevant entities around me, that rely upon your existing power. So far, I've gleaned the complaint for mischief is an allegation that there's a broadening of power by talking to the FIU or by talking to the Commissioner of Police. Let's for a moment leave the fact, yeah, talking meaning receiving, talking meaning I am asking you to give me a report, right? And then saying that the FIU or the Commissioner of Police may give that report or relevant information. That seems to be the central mischief. And I've heard the member for Caroni Central, and I've heard the member for Oropouche East just say something which Oropouche East actually put very clearly forward, and I thank him for it. The recommendation was, rely on your existing powers. Because we accept that Section 25(3), Section 32, Section 33, Section 37 of the Act exists. I'm asking now, if the government were to remove in 22B, let's start there, because that's where we are. If the government were to remove, if we look to the marked up bill, 22B, 1B, that facility where the Attorney General asks the Commissioner of Police for something, and then in 1A, where we say that the Commissioner of Police should provide the Attorney General with relevant information, if we remove those two clauses, will the opposition support the recommendation of the JSC? Let's focus. The mischief as painted. No, I mean mischief in law, right? The concern. The concern that has been painted is that the Attorney General is being given two routes which cause concern. On the first route, the concern is, look, you're asking the FIU for information, and that is something which causes concern because the Office of the Attorney General under our system is a political appointee. So don't ask the FIU, that causes concern. That's the first concern, first route. The second concern is in 22B. In 22B, we insert the ability for the Attorney General to ask the Commissioner of Police to do something.
It's very difficult hearing it. This is a very complicated bill.
Okay.
Very complicated.
So I just wanted to get the idea first because it now hinges upon another statement that I want to make. So if I could ask the Honourable Member for Sipari if she has a copy of the marked up version of the Act or bill? Yeah? Okay. If we look to 22B, the matters which are in red, right? We see clause one, subclause 1, where Attorney General receives information. We go past A, we get to B. B says, cause an investigation. He may, for that purpose, refer it to the Commissioner of Police, who may cause an investigation to be carried out. That seems innocuous enough because you're just sending it to the Commissioner of Police. The concern arises in the next one, 1A. Where the Commissioner of Police receives a referral, he shall, as soon as the results of the investigation are known, provide the Attorney General with the relevant results. If we were to completely delete that 1A, there's nothing wrong with sending it to the Commissioner of Police for an investigation. So if we took out 1A entirely, and do the same thing for the FIU. So that's 22AA, which we passed already. These are the two blocks right now. The opposition's submission is that, listen, Attorney General, if you have this law the way it is, as you are putting it now, where you can get the Commissioner of Police to give you information back, or the FIU to give information back, the opposition's submission is bring in the DPP, which I have some constitutional issues with, right? If I were to completely delete 1A, then the existing law can stand. Then we can revert to what Oropouche East has said, which is rely on your existing position. And I want to genuinely thank Oropouche East for focusing upon that just now. I confess, it's not often you hear me complimenting Oropouche East, right? I confess that passions are high. So, Madam Chair, would it be... Yes? Good. So I'm hearing, if you'd permit me, I'm hearing the Honourable Member for Siparia say, write it up so we're clear.
So,
Yeah?
Can we put on
Sure.
this? It is circulated writing.
I can do that if you would permit the opportunity, Madam Chair.
We will therefore leave clause 27 and revert to clause 27.
We can come back.
Yes, so we can come back to the two bits that cause us concern, because it seems to me this is the stumbling block.
26.
Right? Yeah, 26 and 27, clauses 26, which we've passed, which is the FIU bit, and 27, these are the two stumbling blocks. FIU, the Attorney General's touching the FIU starts in 26, right? Clause 26 treats with an amendment to clause 22A, double A. So we passed 26 and we voted on it and we took a position.
We're on section 22B now.
Yes, so on section 22B, which is clause 27. So if the government were to reduce the proposed amendment to writing so that my learned colleague could see it in context, and I agree with it, it's not something to do off the cuff like that, would the opposition be minded to consider at least that position?
We'll consider any proposal that you put, that is properly put to the House.
Because that will avoid the whole need to say, replace AG with DPP.
Yeah.
Yes?
Maybe. I have to look at it, I'm saying.
Sure.
I will have to see it in the proper form, Madam, through you.
Okay, so can I therefore suggest
We
clause
defer.
27 and clause 28, because my quick glance at clause 28 and the amendments that are being proposed may raise a similar issue.
Yes, ma'am.
Yes? So may I suggest that clause 27 and clause 28 be deferred?
Yeah.
And we revert to them when
Agreed.
this further amendment.
Yes, ma'am.
And therefore, it will mean, because we have two sets of amendments for 28, but we will defer 28 altogether. And therefore, we will then consider 29 to 33
29.
as a block, and then we do 34.
Uh-huh.
Yes?
34 may I intervene?
Yeah.
34 also has AG to be
All right.
replaced by DPP, so.
So, okay. So we do 29 to 33. We will then do 35.
45.
We will then do 35
45.
to 45. And then we'll do the new clauses, 46, 47. Okay. All right, so if there's anything, we suspend if they're not ready. Okay. All right. So we do what?
So we're going 29
to 33.
to 33.
Okay.
Clauses 29 to 33.
Honorable members, the question is that clauses 29 to 33 stand part of the bill. The question is that clauses 29 to 33 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 29 to 33 now stand part of the bill. We will defer clause 34, and we now go on.
Clauses 35 to 45.
The question is that clauses 35 to 45 stand part of the bill. The question is that clauses 35 to 45 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 35 to 45 now stand part of the bill. Now, may I suggest at this stage we suspend, because according to the procedure, we cannot entertain the new clauses before we finish the current clauses. So we give the Attorney General an opportunity to reduce into writing the matters, and then we will come back and do those that we have deferred, and then consider the new clauses. Okay? So, okay, so, all right, so that I get the sense that half an hour should be adequate. and therefore we will resume here at 7:35. Yes? So this committee is now suspended to 7:35.